Student Press Law Center was instrumental in getting us the legal advice we needed to proceed with our story.
I called when someone threatened to sue me.
They're the reason I still have a job.
Since 1974, the Student Press Law Center has worked at the intersection of law, journalism, and education to defend student press freedom. Contact SPLC's legal hotline, and our attorneys can help you with things as simple as copyright questions or as complex as strategizing to fight censorship. Our services are always free. Find the legal hotline and additional resources like legal guides, tip sheets, quizzes, and information for advisors at splc.org. SPLC is committed to fighting censorship and promoting student press freedom. We've helped thousands of student journalists, and we want to help you too. So write the story. We've got your back.
We want to welcome everybody, and with our sunny guests here with the sun shining on their faces. My name is Hadar Harris, and I am the Executive Director of the Student Press Law Center. And we are thrilled to be here at the JA Convention to talk with everybody about some recent, really important developments in free speech law and as it implicates student journalists and student free press rights. I want to thank JEA for having us here to discuss it. But before we begin, I want to be sure that we are flagging for everybody Student Press Freedom Day, which is coming up on February 24th. With the theme Unmute Yourself. It's a perfect Zoom era theme. Every time you forget to unmute yourself, you can say unmute yourself. And Student Press Freedom Day is on February 24th, which also happens to be the Tinker anniversary and also happens to be the Thursday of Scholastic Journalism Week. You'll see lots more information coming out about it. You can check out the website at studentpressfreedom.org. And as always, if you have any kinds of legal questions or any problems around censorship or other issues, you can always reach out to us at the Student Press Law Center. Write the story, we got your back. I just like that, so I'm going to keep saying that. Today, we have two very special guests to talk about the Mahanoy case. And they're going to talk about how you actually pronounce it correctly as part of what they're going to talk about. Sara J. Rose is the Deputy Legal Director for the ACLU of Pennsylvania. Since joining the organization as a staff attorney in 2006, she's litigated a wide range of civil liberties issues, including racial justice, student rights, prisoners' rights, LGBTQ, impact litigation, all kinds of different things, including freedom of speech. She has a great bio, but really one of the most important parts of her bio is the fact that she was a publications fellow for the Student Press Law Center. And we continue to see her footprint on the work that we do, both in terms of publications, but now in terms of Supreme Court precedent. She received her law degree from Georgetown University Law Center and her undergraduate degree in journalism from the University of Maryland in College Park. And she is talking to us from Pittsburgh. Mike Hiestand has been integral to SPLC's success since 1989. He was an intern, then he was the first legal fellow, and then he served as the first full-time staff attorney, and he is still here with us today. And he worked closely with Sara Rose and with a slew of pro bono attorneys and partners to write an amicus brief for this case that was not just cited in a footnote, but actually was part of a concurring decision. And so we're very proud of that as well. So what are we talking about and what is this all about? Mike, I wanted to give you an opportunity to actually give us a quick history and summary of student First Amendment cases that lead us up to this F-cheer case, as we like to call it, because that's easier to pronounce. That we're going to be talking about in detail with Sara Rose. So Mike, can you give us a little overview?
Yeah, so I thought what I would do before I turn it over to Sara is, just kind of give the run up and kind of place, where this case fits into the whole lineup of student press cases. So I'm going to just give I'm going to share my screen on this one. Oh, I guess I need have my screen sharing enabled. Sorry about that.
Screen sharing privileges. You should be able to do it now. We're keeping it real. And just to remind you, unmute yourself. Next year's Student Press Freedom Day event might be called Become a Co-Host. I don't know.
All right. Can you see my screen there?
Okay, it was funnier in my mind. Go ahead.
All right. So and Sarah, let's get it out of the way first. How do we pronounce this case?
It's BL versus Mahanoy Area School District.
Mahanoy. Okay. Mahanoy. All right. So Mahanoy actually fits into this kind of there's been 5 cases involving student speech that have come up before this, really 4 big ones. The first one, I was even hesitant to put it in here because really it was more of it almost, when you read that opinion, it looked a little bit more like a civics education sort of case and really a First Amendment case. But in 1943, the Supreme Court handed down a decision which said that students, and particularly in this case, they were Jehovah's Witnesses students, had the right not to have to stand and salute the flag, give the Pledge of Allegiance. And they talked about, the importance of schools and educating young folks for citizenship, and they just barely touched upon their reasoning for rejecting this West Virginia rule that required students to pledge allegiance in the First Amendment. So it was a brief mention kind of the First Amendment and the role that the First Amendment played. And basically the rule that kind of came out of here is that students do have some degree of First Amendment protection, but it wasn't a real ringing endorsement for that. The first case really that we always have to start with when we're talking about the First Amendment relationship to students is the big landmark, the Tinker case. Handed down in 1969, the facts started all really kind of came to a head in 1965. Students from Des Moines, Iowa, the Tinkers, John Tinker had gone to Washington, D.C. and seen an anti-war, anti-Vietnam War rally taking place. Vietnam War was really just starting to heat up in 1965. And along with his church group, they were all very moved apparently by their experience in Washington, D.C. So on the way back in their van trip back to Des Moines, Iowa, where the family lived, they said, what are we going to do? And so they said, let's wear a black armband to school to show our displeasure with what's happening with the war. Long story short, they ended up being suspended for wearing the black armbands to school. The case makes it all the way to the Supreme Court. And it really was the first time, a lot of folks are, it's kind of surprising, I think, but it really is the first time the Supreme Court had the question directly on their in front of them: are students protected when they are in school by the First Amendment? Do students retain some sort of First Amendment protection? And the court answered in the affirmative. I mean, and then the big the language that came out is that neither teachers nor students shed their First Amendment rights at the schoolhouse gates, that students are citizens, they are protected by the First Amendment. A big part, they also talked about the importance of civics education and instilling in young folks in our next generation an appreciation for the First Amendment and the Constitution. So the language that came out of the Tinker case is said that students have the right to engage in expressive activities on campus as long as their as long as their speech is neither unlawful, and we're talking about things like libelous or obscene or invade somebody's privacy, things that really none of us are allowed to engage in. There's a certain forms of speech that courts have said are unprotected. But the second prong that came out of the Tinker case is that the court said that school officials can also censor students when they are engaged in speech that creates a material and substantial disruption of school activities. Basically, a serious physical disruption that doesn't allow sort of normal school activities to take place. So that really was the ruling for Tinker, and Tinker was the law that remained in effect for about 20 years. I mean, the Supreme Court pretty much left Tinker to be, to be the case anytime a case came up where there was some sort of expressive activity involved. Tinker was the go-to case. Tinker was what the court looked to determine whether or not school officials could censor it or not. So like I said, that was the law for about 20 years. And then in the mid 1980s, the makeup of the Supreme Court had changed fairly significantly. The court had gotten a lot more conservative, and they decided to kind of enter back into the fray. Now, one of the things you notice is and if you ever have time, I encourage all of you, go read the Tinker case. I mean, it really is a pretty optimistic, forward-thinking view about, sort of the role of student voice, the importance importance of student voice and protecting that. And, just a very optimistic thing that students have ideas, have voice, have opinions that really are worth protecting in the law. And so it was 1986 the Supreme Court got back into the student speech case, and it was really kind of, you read the cases from Tinker to Frazier, and it was almost an issue of like buyer's remorse. And it really did seem like the court said, we just went way too far with the Tinker case, and we need to start pulling back. And so their first opportunity to do so came up in this case, Bethel School District v. Frazier. Bethel School District is actually about an hour south of me. I'm up in Washington State, just outside Seattle. But Matthew Frazier had been asked to basically give the nominating speech for his friend who was running for class president. And in this speech that took place in the school auditorium, students were required to attend this thing. In the speech, he had a lot of I don't know, sexual innuendo, I guess is the best way to describe it. The Supreme Court had a hard time describing what it was too, but he used kind of a lot of sexual innuendo, sex talk kind of stuff to kind of in this nominating speech. Apparently people that were there said that students, they hooped and hollered and everything like that, but for the most part things went on, and he finished his speech. He ended up being suspended as a result of the speech. His case also goes to the Supreme Court, and in this particular case they said, what, we think that, again, the makeup of the court had changed, and that really is significant because they really did not want Matthew Frazier to be allowed to give this speech. I mean, if you just looked at Tinker and you applied Tinker straight up, I think, there was nothing unlawful in Matthew Frazier's speech. There really was nothing that created that level of serious physical disruption that Tinker seemed to require. It was just kind of some hooting and hollering in the audience. But the court said, what, we cannot, tie the hands of school officials. And so they said, going forward, we're going to allow school officials to censor a speech that they described as profane, lewd, indecent. They had a really hard time, again, trying to figure out exactly what it was that Matthew was doing, but they didn't like it. And they said school officials have the right to censor that sort of speech. Couple of years later, and this is the case I think all of us in the audience are familiar with, hopefully, the Hazelwood case. It directly addressed the question, what sort of rights do students working on a school-sponsored student newspaper have? And unfortunately, as most of you probably already know, the outcome of that was not good at all for student journalists. It really did, turn back the clock in terms of the protections that are available to student journalists. It said that school officials, if we're talking, and they made this big distinction again between the speech of Mary Beth Tinker and her brother, the black armband that they made at home, and this school-sponsored student newspaper. The court had never really made that distinction between what they called school-sponsored speech, like the student newspaper, and non-school sponsored speech like Mary Beth Tinker's armband. But they did so in this case, and they said, because they're two different types of speech, we believe that there should be two different types of standards. And the standard for school-sponsored student expression is that school officials can censor that speech where they have a reasonable educational justification. So where school officials can show that their censorship is reasonably related to some legitimate educational goal, courts have said that would be sufficient. Unfortunately, the court did not define exactly what that meant. They gave some examples that if anything muddied the waters. They said that school officials could meet that reasonable educational justification standard, where they said that the speech, an article in the student newspaper was, for example, poorly written or inappropriate for a particular age audience. If it was ungrammatical, they could censor it. If it was my favorite, if an article was inconsistent, this is quote, inconsistent with the shared values of a civilized social order, unquote, that was enough to censor. I mean, just crazy stuff. And it really did, it really was this sea change for student journalists that before Hazelwood, we had Tinker, and really we had some really good law that protected the rights of students to write the sort of stories they wanted. After Hazelwood, that changed fairly significantly. And as a result, we've had to push back. We've had, an effort to pass state legislation that would counter some of this stuff in the form of new voices legislation and stuff that is the subject for another talk. But so that was the Hazelwood case in 1988, and the last case before the one we're going to talk about today was this case Morse v. Frederick, the infamous Bong Hits for Jesus case. So the Olympic torch was on its way to Salt Lake City, and as you know, they run the torch through various communities, make a big deal of it. They were running through Juneau, Alaska, and nothing much ever happens in Juneau, Alaska. And so one of the students there said, "You know what? I'm going to take advantage of the fact that TV cameras are going to be here and press is going to be here, and we're going to hold up this big banner, 17-foot long banner that just says Bong Hits the number 4 Jesus." He said he'd seen this. Joseph Frederick, the student who did this, said he'd seen this on a bumper sticker up at the ski slope that he liked to snowboard at, and he said it had absolutely no meaning that he could think of other than he knew it would upset school officials. And it did. The principal walked across the street. Now, this is really important to what we're going to be talking about in just a second. Joseph Frederick never came on school grounds that morning. In fact, he never was in school the day that the torch was running through. He stayed outside of school, and he and his friends were the picture you're seeing here is across the street from the high school on a public sidewalk where they held it up. But the principal decided that she would go across the street, take the banner down, call Joseph Frederick into the office where he was suspended for 5 days until he cited Thomas Jefferson, whereupon she increased the suspension to 10 days. And so the case went to the Supreme Court. And in this particular case, I mean, it was so much ado about nothing in the end. But basically what the court said is that that the school officials can also, in addition to what they said in the Frazier case about profane speech and what they said in the Hazelwood case about school sponsor or student newspaper speech, they could also ban speech that advocated illegal drug use. Now, I think there's a big question about whether this banner actually did anything and were in the way of advocating drug use, but that's what the court said. School officials can also can ban speech that advocates illegal drug use, but they also rejected very quickly our argument, and it was our argument at SPLC that we led with because we thought it was a really important piece that this speech had taken place outside of school, that it never had, this was not anything really having to do with school. Court rejected that immediately right out of the blocks. They said, you know what, this is what we call, they created a new category. Basically, they invented this category they called school sanctioned speech. So in Hazelwood, we had school sponsored speech. School officials could censor that. Now we have school sanctioned speech that even if it takes place physically outside of school, the court said that because the school, let the students out of class and, kind of officially, and apparently there were teachers that were kind of monitoring things. There's enough school involvement that the Supreme Court said it was school sanctioned, and therefore they had no problem allowing school officials to actually censor Joseph Frederick's banner. So that's kind of where we are leading up to the Mahanoy case, at which point I'm going to turn it over to you, Sara.
And so, Sara, we've got, school sanctioned speech. We got these guys with this big banner across the street from the school. There's some kind of weird nexus there, but then we've got the really disgruntled cheerleader, Brandy Levy. Can you tell us a little bit about the facts of the case, kind of where it leads, and follow Mike's continuum?
Sure. So I represented Brandy Levy. She at the time that she and her dad came to the ACLU, she was a 14-year-old freshman. She was a member of the JV cheerleading team, also played on a private softball team. She was hanging out with a friend at a local convenience store called the Cocoa Hut on a Saturday afternoon, feeling frustrated with, exams. She didn't get the spot she wanted on the softball team, and she also didn't get the spot, was not able to join the varsity cheerleading team. So they told her she had to spend another year on the JV cheerleading team, which she was upset about. So she posted a snap on Snapchat that said, I don't know if I'm allowed to use the profanity or not.
Use it.
Let's go with F.
Okay.
Or let's go with F.
Okay. Oh, okay. Yeah, I just want to make sure.
It's a high school audience. I'm pretty sure they've heard the word, and most of them probably used it, but just to keep it here.
But she used the actual language.
She
Yeah,
she used all 4 letters of it.
Make it clear. We had the same debate about whether we should say this word in front of the U.S. Supreme Court too. So.
And they said it for you.
And they did.
So anyway, so she posted a snap that said F school, F cheer, F softball, F everything. Along with a picture, it was a caption to a picture that she took of herself and a friend at this convenience store with their middle fingers raised. And she posted on Snapchat, on her Snapchat story, which means it's available for 24 hours to view by any of her Snapchat friends. She had about 250 Snapchat friends at the time. We have no idea how many people viewed it, but we do know one person who viewed it, who was not in fact one of her friends, but was the cheerleading coach's daughter. She saw it on another student's Snapchat and took a photo of it with her phone. And that's actually the only evidence we have of this snap, because on Snapchat things disappear after 24 hours. But we have this photo that, like a screenshot that was taken with another student's phone. That student showed it to her mom, the cheerleading coach, and the following week at school, Brandy got called into the cheerleading coach's office, asked if she posted this snap, and said that it violated the cheerleading rules and she would be suspended from the cheerleading team for the entire year, but she could try out for her junior year. So Brandy was understandably very upset with this. She loved cheerleading. She was crying. She went to the office to call her mom. Her parents were upset that the school, punished her by suspending her for the team for a whole year for something that she did outside of school, right? She was on her own time, outside, off school grounds on a Saturday. And they didn't think that it was the school's job to punish her. And so the parents tried to talk to the coach, talk to the principal. They even talked to the school board, and they wouldn't back down. They came to the ACLU. We did what we do a lot of times. We sent a letter explaining why we thought that the school district's decision violated Brandy's constitutional rights. And honestly, we thought that would resolve the situation. Most of the time it does, but not here, obviously. Instead, the school district wouldn't back down. So we filed a lawsuit. We asked the court to enter what's called a temporary restraining order, immediately restoring Brandy to the team. The judge did that within 24 hours, which I think is a record, at least in our cases, for how fast one of these orders got entered. So she got back on the team for her sophomore year. She remained on the cheerleading team until she graduated from high school. No further incident. But in the meantime, she was the plaintiff in this federal case. She had to testify at a preliminary injunction hearing. She had to sit for a deposition. The trial judge granted our preliminary injunction motion. He granted our motion for summary judgment, which means we won in the trial court. School district appealed to the U.S. Court of Appeals for the Third Circuit. We won in the Third Circuit. And in fact, we won such a good decision in the Third Circuit that I think that's why we ended up in the Supreme Court. So at the ACLU, we have been trying for the past 15 plus years to get a decision out of the Third Circuit saying that schools do not have the power under the First Amendment to punish kids for what they say off campus. And I remember when I first started working at the Student Press Law Center, these cases were just bubbling up. So that was back in 1999. And in fact, when I was there, I interviewed the current legal director for the ACLU of Pennsylvania for a bunch of stories, because he was doing these cases all the way back then. As soon as the internet students started using the internet, there were a lot of schools that were finding out what kids were saying on the weekends and off campus, and punishing them for it. And so we were trying to challenge that. And so, we've been working on this case. We had a couple cases that went in front of the Third Circuit about 10 years ago. And in those cases, the circuit said, well, we're not going to decide whether schools can punish students for off-campus speech under the Tinker decision, because we don't have to decide that in order to rule in these cases. So we had never really gotten a decision. Finally, even though we didn't even argue it in this case, because we thought the facts were so clear that there was no disruption, right? Under Tinker, there at least has to be a disruption of school for the school district to punish. Here, there was no disruption. So we didn't even argue that Tinker shouldn't apply, because it didn't matter whether Tinker applied. There was no disruption from her snap that she posted off campus on a Saturday. Nonetheless, two of the three-judge panel decided that they wanted to take this opportunity to hold that schools cannot punish students for off-campus speech simply because it creates, even if it created a material and substantial disruption of school. Like basically schools have to rely on the same First Amendment principles that apply to everyone else in order to punish kids for off-campus speech, which is, the ruling we've been asking the court to issue for so long. But, be careful what you wish for, because that resulted in the school district asking the U.S. Supreme Court to hear the case, and the court did, which is a little bit surprising in this case, given that, all along we didn't think there was no disruption, so really it didn't matter. But so the court agreed to hear the case. And should I get in the decision now, or do we want to talk a little bit more?
Yeah, we've got this opportunity to ask you, like, behind the scenes. It was surprising that they took this case, right? I mean, this wasn't a great case on the facts. This wasn't, and even in the argument, as we were sitting and listening to the argument, there was a lot of discussion by the justices about, we're not going to write a new First Amendment treatise on this case. So what did you guys all think? And what did Brandy and her parents think when they took it all the way up?
Yeah, so, we argued pretty strongly in our brief in opposition to the petition the school district filed for the court to hear the case, that even if you answer the question that the school district's raising, which is, does Tinker apply to off-campus speech, we still win, right? So there's no reason to take this case. Right. But I think that, given the breadth of the Third Circuit's decision, that was probably the motivating factor for the court to take the case. And I'll tell you, I remember very clearly when I looked, I saw in my email that the court had granted the school district cert petition. I think I used the same word that Brandy used in her snap, because I was so surprised by that. Yeah. I mean, I was shocked. I had told,
I used the word if you did.
Yeah, I will tell you, it traveled across Zoom, across the miles.
So, I had told Brandy and her parents I thought it was unlikely. I mean, the court hardly hears any of the cases that people ask it to hear. So, so it was surprising that they took this case. But, it was also, a great opportunity, because for me, it was a great opportunity personally, because again, I started, my career at the Student Press Law Center. This is such an important issue to me, for the ACLU of Pennsylvania, which has really done a lot of student speech work. It's a great opportunity for us, our affiliate, to do this work, and also, for the National ACLU, which actually we've represented Mary Beth and John Tinker. We've represented the student in Fraser, and we represented the student in Morse versus Frederick. So it's, so we felt like if the court's going to take a case, this is a good case for it to take, because, of the involvement of the ACLU, and also the facts were on our side for this case, right? It's not a case involving, threatening speech or harassing speech. It's simply profanity. And in fact, the school district initially argued that they should be able to punish her under Fraser because she had used profanity off campus, and she had agreed to these cheerleading rules that they said didn't allow, her to use the profanity. So in that sense, we thought it was, we were, in that sense, it was a good case for the court to take up. But at the same time, it was a little bit surprising, given that ultimately, and I think that the decision bears it out, that ultimately it didn't really matter to what the court decided, to the ultimate outcome of the case.
I'm curious, when I was listening to the oral arguments, were you it just seemed like this light bulb was kind of going off in some of the justices' head, like, what have we done here? What sort of box have we opened up here? Did you get that sense too, that they didn't quite understand how big this potentially could be the decision they were going to make?
Yeah, there seemed to be a bit of buyer's remorse during that argument,
Yeah,
which, as a lawyer who's worked, countless hours preparing for this case is a little bit frustrating. And of course, coming into this case, we argued, very strongly in the Third Circuit in those previous cases that, schools, students shouldn't be subject to different First Amendment rules when they're outside of school than anyone else, right? Everyone should be subject to the same rules when they're outside of school. Tinker is premised on the special characteristics of the school environment, and those are non-existent when you're outside of school. So there's no justification. So, from my perspective, I wanted to kind of, come in swinging with that argument. And then, it's a very interesting process. The first time I've had a case in front of the US Supreme Court, and it's a very interesting process to see, to get that dose of realism from people who are saying, well, do you want to win this case or do you want to stick to like that argument? And so you realize you do have to make some compromises about, what is actually going to move the justices. It's also very different to have a case where, the Supreme Court, it has its, in this case, it had never had a case before it in which it decided, the off-campus rights of public school students. And there, it's not like when you're in the Court of Appeals where you can look to US Supreme Court precedent, right? They're making it up. And so trying to tie it to existing areas of the law, it's a very different process than even, litigating a case on the Court of Appeals.
Before we go too much further in that, because I know Mike and I both want to hear all the backstory, but why don't you just kind of finish and tell everybody, what did the court actually decide? Because there was a raucous, discussion in the Supreme Court, and then a lot of people listening on the outside. The oral argument happened in deep COVID time. And so it was all on the phone and people could listen to it. But tell us what the holding was and what you think the impact of it is.
Before you do we know?
Before you do that,
has the Supreme Court ever used foul language like that? I mean, was history setting in terms of? No, they've done that. Okay.
I don't think so. I think they've used it before.
One thing I don't know about that, but I do know that in the there's a case where someone wore a jacket that said F the draft, that was the full word, into a courthouse. And that's a really famous case about the right to use profanity, that the one of the first words out of the lawyer for the plaintiff's mouth in that case was the F word.
Okay.
I remember 7 dirty words.
Whether should we use this word or not in the court?
Well, good. I was wondering if they'd ever crossed that line. So thank you.
I don't know if the court used that word during the argument or not. So
yeah.
But so ultimately Brandy won. It was an 8-1 decision. So that was, a fantastic result for her. It was fantastic for me because I was a little bit worried we'd have to go back to I thought we'd ultimately win, but the court could have, instead of ruling for Brandy, they could have sent it back to the Court of Appeals to make a decision, which would have obviously just been prolonging the case. I mean, my client, Brandy, she's 14 when this case started, a freshman in high school. She was a freshman in college. In fact, she just finished her freshman year of college by the time we got the decision. She's, as she would say, she's from a small town in rural Pennsylvania, never expected any of this to happen. It's just amazing. Unlike, the Tinkers where they were engaged in political expression, this was just an offhand comment she made out of frustration. But, as her dad said, those are also important, right? That's a way for kids to, blow off steam. It's a way for parents to find out how their kids are feeling, right? If they were to see it on social media. And that's just the way kids communicate today, right? And just, you have to recognize that even if it's not maybe the highest form of political speech, it's still really important to ensure that kids are able to engage in that kind of speech. So she won. She was very happy. I think she was like equally relieved that the case was over and that she won. Like both of those were very important to her. And ultimately the court, I don't think, I think that the main takeaway from this decision is that school districts have to exercise caution if they're going to punish kids for off-campus speech. I think we've seen over the years that the Tinker standard has really been watered down in the lower courts, and a real fear that we had about this case was that, if the court just extended Tinker to off-campus speech, then that would result in, kids being punished much more frequently. Like, I think schools have been somewhat cautious in punishing kids because they didn't know where the line was. And the concern was if you took that line away, that they would just extend all the kids who get punished in school for speech, that's going to extend to off-campus speech and really have a real chilling effect on kids' willingness to engage in speech when they're outside of school. But here, I think the court really set some pretty clear boundaries in terms of, the schools have to be careful, right? I mean, they have to have a really good reason for punishing kids for off-campus speech, and that reason has to be related to the special characteristics of the school environment. So I do think that will be helpful going forward in terms of, preventing, what could have been a really harmful impact from extending Tinker to off-campus speech.
So with all of that, where does that leave student journalists? Both of you, Sara, you've, worked with SPLC, and Mike, we wrote a brief about that, among other things. And so where does this ruling now leave student journalists in thinking about off-campus speech, or does it give student journalists a little bit more permission?
I'll just feel, I mean, that's the one good thing. I mean, there's a few good things came out of this case, but the one good thing, I think for student journalists, for students that truly are engaged in bona fide sort of journalism activity, they're trying to gather, information, report that information out accurately. I think this decision is a slam dunk win. It just says, school officials, back off. You really have absolutely no role to play when students are engaged in that sort of expression off campus. I don't know, would you agree with that, Sara?
Yeah, I think that, importantly, the court noted that, schools are pretty much never going to be able to punish kids for off-campus political or religious speech. Like, they made a pretty clear line in the sand for that. And I think that a lot of journalism could fall into that sort of speech. But I also think, maybe even more importantly, the court specifically recognized the danger of the heckler's veto. And when I say heckler's veto, I mean if you were to say something that other people disagreed with, and those people then caused a disruption because they just disagreed so strongly with your speech, we could easily see a situation where student journalists are reporting on a problem in the school, right, that creates a lot of outcry among the community, or can create a disruption in the school because maybe people didn't know about it before, right? They could be reporting on, any kind of whistleblowing activity, like, racism or sexism, or, school officials misappropriating funds. All kinds of things that student journalists could report on outside of school could create a disruption in the school. And that's one of the things we really focused on in our argument, was this idea that if you allow schools to punish kids simply for a disruption without caring how the disruption is caused or why it's happening, then that could really be harmful in terms of whistleblowing and sort of just understand, people being able to talk about what happens at school and really important information. And so the court specifically said, like, that it cannot be a basis for punishing kids for off-campus speech simply because other people may disagree with the views that they're expressing. I think that was an important protection for student journalists.
And in a situation of, Mike, we've talked a lot about underground newspapers or off-campus newspapers, right? In a situation where student journalists are actually being censored under Hazelwood, but they have a story to tell and they've reported something, and they decide that they're gonna, what we anecdotally say, go rogue, and they're gonna set up their own newspaper or website. This gives them kind of cover to be able to do that, right? So it's like a win against censorship in many ways, because it gives them the affirmative right to be able to publish what they need to publish.
Absolutely. Yeah, no, it's 2021 and not 1988 when Hazelwood was handed down, or there are so many options, and that is one. That's one thing that's changed, I think, since you've been here, Sara, is you heard me, explain Hazelwood ad nauseum. I'm sure we had offices that were right next to each other. I do a little bit of that, but my leash has gotten much shorter with school officials. I mean, if we think that they're going to be open to persuasion or, reason, we'll try and do that. But if it just looks like they're just going to shut the students down, we start talking pretty quickly about alternatives and going off campus. And this decision definitely, again, for student journalists, this was a really, really good decision, I think. For other students, I mean, I was a little disappointed. I don't know about you, Sarah, but Briar's, we were looking for, just kind of a bright line. One of the things we talked about in our brief was like, don't Hazelwood us again by giving us, some sort of just, murky, muddy sort of decision that I have to spend so much time just trying to explain, whether it applies to you or not. We asked for a bright line, and he didn't really give that. I mean, he gave some examples, cyberbullying and threatening speech and stuff like that. But, stuff that's between like bona fide journalism and cyberbullying. I mean, there's a lot of middle ground there, and I don't know exactly where we go from here. I mean, I think there's going to be a lot of litigation. I don't think this in any way is going to close that down. And if anything, I think it maybe opened it up a little bit.
Yeah, I definitely think that's going to be up to the lower courts to define the contours of this decision and how it applies to students. So, for people who like to litigate First Amendment cases, I guess that's a good thing, but it might not be. I mean, I think for students in school districts, it still leaves a lot of gray area. And it's going to be years before I think we have a better sense of how this decision will play out.
I mean, you probably sat in some panels with school administrators following this. They're actually happy with it. I mean, they many of them are, it's a decision that they feel they can live with. And I get it. Yeah, there's no bright line that says you cannot punish students ever. The one thing that I think was a real big positive about this case is it kind of stopped the pendulum. I mean, we had Tinker, we had this great, optimistic, wonderful case in Tinker about the importance of student voices, and then it all kind of went downhill from there. This, I think, at least stops that drift and just says, wait a minute, school officials, you do need to recognize that student voices are important. You do need to recognize the importance of schools in, instilling in our next generation kind of civics education. I mean, the language that we're going to use, that language that Briar wrote, about schools being nurseries of democracy. We've used that already over and over, and we're going to use that a lot. I mean, that it really is important stuff. But yeah, just as it left a lot of questions unanswered.
Well, it is the first case in 50 years involving student speech when the student won, right?
Yes.
So,
and you did it. And you did it. Thank you, Sarah.
And on that note, that's not a small thing at all. I want to be mindful of our time and know that we're coming up to the end of our session. But I want to congratulate you, Sara, for your amazing work on this case and on all the cases that you're working on. We are very proud of what you've done. And of course, we will take full credit as your time at the Student Press Law Center, has led you to where you are. And we're also really proud to be partners with you, and look forward to the next go round when we can partner together on an important case like this. I want to thank you both. And I also want to just note that in 1978, in FCC versus Pacifica Foundation, we should never forget the 7 dirty words that were professed right out there in open court there in the Supreme Court. And, if you really want to investigate what the 7 dirty words were that the FCC was talking about, being unsuitable for public broadcast, there's another free speech case for you to take a look at. And if you want to look at the lore of the Supreme Court and profanity, check that one out, because it goes way beyond F-cheer. So with that, I want to say thank you very much to Sara Rose and to Mike Hiestand. We want to remind you about Student Press Freedom Day on February 24th. Unmute yourself. And for sure, if there are any questions that come up, if you feel that you've been censored or that your First Amendment rights have been, as a student journalist, have been abrogated in some way, or you have some other media law question, please contact the Student Press Law Center's legal hotline. More than likely you get to talk more with Mike and he'll tell you some more stories, or with Summer Dean our other staff attorney. We look forward to hearing from all of you. And thank you very much for your time today. All the best. Bye.